Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about a crazy case out of the state of Washington. This case came down at the end of the week. It caused a lot of confusion, and I was about to do a video about it, and then it changed. And usually when the Supreme Courts of states act, they act very, very slowly. They make glacial sound fast. But the Supreme Court in Washington did something crazy and then actually issued a clarification of its craziness, which doesn't make it any less crazy. But this is an insane case out of Washington, no matter how you slice it. So let me try to explain this to you. A man who refused to open his door to let police into his house without a warrant was convicted for obstruction of justice. And it made it to the Washington Supreme Court, the state of Washington. So here's what happened, because it gets crazy. A little over 3 years ago in Shoreline, Washington, a late night shouting match between Solomon McLemore and his girlfriend prompted someone to call 911. And I'm getting this story out of Forbes, written by Nick Sabilla, but the story was covered in a bunch of different places. When the officers arrived and demanded to be let in, the yelling stopped and no one answered the door. So after 15 minutes and still no response, police heard glass shattering and, worried about domestic violence, they began forcing their way into the residence. As the officers broke down the door, McLemore told police they were infringing on his rights and that they needed a warrant. Officers also heard McLemore tell his girlfriend to tell police that she was okay. Now, once inside, police determined that the woman was not injured, and they promptly handcuffed McLemore. And he wasn't charged for domestic violence. Instead, police arrested McLemore for obstructing a law enforcement officer. And they simply said, when he didn't let us in, we asked to be let in, when he didn't let us in, he's obstructing a law enforcement officer. And so, under Washington law, it's willfully hindering, delaying, or obstructing any law enforcement officer in the discharge of his or her official powers or duties. And for refusing to open his door to the police, McLemore was convicted for obstruction and sentenced to 20 days of house arrest. So the entire thing boils down to the cops show up and knock on your door. And let's suppose you ask them, do you have a warrant? They say no. They say, okay, open the door up anyways. And you say no. According to this, if you're in Washington State, they can arrest you for that. So it went up on, it went to trial and went up on appeal. And on appeal, McLemore didn't challenge the city's forcible entry into the home because he conceded it fell under a warrant exemption for community caretaking. And it makes sense. The police show up at a residence where somebody says, I heard someone screaming. The police hear glass breaking. They can assume that that's possibly some kind of violence. And so they've got to get in there and try to protect somebody that they presume could be in danger. Okay? That logic makes sense. But that's not what we're litigating here. We're not litigating whether the police have the right to enter. We're litigating whether or not the homeowner has the right to not open the door for a cop who doesn't have a warrant. Okay? And I think this is one of those situations where 99.99999% of all Americans who have an IQ above room temperature, as they say, would understand that, hey, if they haven't got a warrant, I don't have to go and put out the red carpet for them and bring them in. That doesn't make any sense, especially, with the Bill of Rights and whatnot. So it seems kind of crazy, but the court wrote that it is undisputed that the officers here responded appropriately and lawfully to a potential domestic violence situation. But whether residents had to comply with a warrantless entry was a different matter entirely. The justices noted there is no law requiring people to open their own doors to officers seeking a warrantless entry. Makes complete sense, right? Gets crazy. While cooperation with the police might have been wise, the failure to do so is not criminal under these circumstances. Again, that's the Supreme Court Justice of the state of Washington writing. And he added, lack of cooperation does not become obstruction of justice merely because it causes the police delay. As a general proposition, there's no obligation to cooperate with the police. So that's, sounds like wise words from the Washington State Supreme Court Justice who's writing this opinion. Now, the ACLU pointed out that when McLemore was convicted, it made Washington State an outlier. In the vast majority of cases called to our attention, courts have held that there is no obligation to open a home to an officer's warrantless demand for entry. That, again, is a Supreme Court justice writing. And he noted that just last month, the New Jersey Supreme Court, on almost identical facts, unanimously held failure to act was not obstruction. And previously, the Washington Supreme Court itself has repeatedly warned in the past that obstruction laws can result in disturbing intrusions into an individual's right to privacy and can implicate other rights specifically enumerated in the Bill of Rights. Hey, the Bill of Rights, turns out that thing's real and actually has meaning. So here's the thing. So the opinion I'm just reading you the language from was issued as the majority opinion a couple days ago. And there was a dissenting opinion that explained why a person who has someone knocking at his door claiming to be a law enforcement officer has got to open the door and let these people waltz into his house without a warrant. And that was considered the dissenting opinion. So the primary opinion, and I'm purposely using that word and not saying majority opinion, is because apparently there are 9 justices on the Washington State Supreme Court, and 4 of them voted one way and 4 of them voted the other way, which is actually a tie. Not making this up. And you know something? When your job involves counting, and you're counting up to 5, it shouldn't be that difficult because you have a handy, catch that? A handy counting device that'll take you up to 5. So to figure out which side wins when there's 9 and you need 5 to win, you count 1, 2, 3, 4, 5. And so you had 4 on one side and 4 on the other side, and somebody, and by somebody I mean a whole bunch of people, didn't catch the fact that the side with 4 votes didn't win. Because if the side with 4 votes won, then they both won. And you can't both win. It's like flipping a coin and having it land on edge. Doesn't happen. Not in real life. Only in the Twilight Zone. So on Friday afternoon, the Washington Supreme Court issued an order that amended the lead opinion by striking out its conclusion and replacing it with the following language. We, in the lead opinion, would hold the city presented insufficient evidence to sustain Macklemore's conviction, and we would remand it to the trial court for further proceedings consistent with his opinion. However, we recognize that this opinion has only garnered 4 signatures. Therefore, there being no majority for the reversal of the judgment of the trial court, it necessarily stands affirmed, and the order of this court is that the judgment appealed from be, and it is hereby affirmed. So even though the lead opinion initially would have reversed the conviction of Macklemore, this court split evenly at 4-4. Macklemore's conviction in the trial court still stands. The rest of this piece was updated accordingly, which is one of the reasons I keep jumping back and forth in tenses here. And it was funny because I had several people send me this, and thank you very much. I'm getting to the point now where I have an entire staff of researchers, just viewers of my videos, who send me interesting emails. And this one crossed my email radar 4 or 5 times. And people are saying, Steve, how is this possible? What's going on here? Because it looked like the Washington Supreme Court was actually saying, 4 of us find this way, 4 of us find that way, but we're declaring this 4 to be the winning 4. And I actually had people saying, is it possible? And I saw people, commentators in the press, in the media, actually saying, how is that possible? You've got to have a majority. And the funny thing is that while researching this, I actually just ran 4-4 Supreme Court through the Googleinator, and I came up with a recent opinion from the U.S. Supreme Court that was 4-4. And that happened because one of the judges recused him or herself. I forgot which one it was. And they wound up with a 4-4. And a 4-4 means that the lower court ruling stands. So a 4-4 often happens if you have 9. And like Michigan's got 7, and so you will routinely get a 3-3 if one of the Supreme Court justices steps back and doesn't partake in a particular case. But here you had a 4-4, and one of them actually thought they'd won and issued the ruling and said, here's the majority ruling. And what makes you wonder about this is the fact that the Supreme Court's got a huge staff of clerks, of secretaries, of attorneys who work, doing stuff in there. And somebody actually said, here's the opinion of the majority, and somebody else says, here's the opinion of the dissenters. And those were, typeset and made official and printed. And nobody bothered to say, wait, 4 versus 4, that's a tie. That's not a win, that's a tie. And you say, I would love, and no one will do this, but I would love it if somebody would actually go to the Washington Supreme Court and just count how many people missed that the 4-4 is a tie, it's not a win. So it took them apparently about 24 hours, I think, to catch that. It may be a little longer, but I seem to recall that the opinion was issued on Thursday and the clarification came out Friday. And, why it took them that long to clarify, I don't know. All they did is write one paragraph. The we in the lead opinion would hold, but, it's kind of weird. But the scary part is that the net result of this odd situation is that right now in Washington state, the current state of the law is that if a police officer shows up at your door and knocks and asks to come in without a warrant, if you don't let them in, you could theoretically be charged with and convicted of obstruction of justice. And that to me is insanity. So I have no idea. I guess it says obstructing a law enforcement officer. Might not be quite the same as obstruction of justice. But I would hope that somebody might appeal this one higher. But you never know. Sometimes, a guy spent 20 days of house arrest. He might not care anymore. But I certainly hope as a matter of principle that he does, or that some of these other organizations along the way might help him and encourage him, because that is a crazy, crazy result. And I don't know what to make of it on the fact that 4 of the Supreme Court justices said, no, that makes sense to us. There's a reason you're in the dissent when you're tied, I guess. I don't know. So it's a crazy opinion from Washington, made even crazier by the fact that it was originally a 4-4 win for the side that had 4 and a loss for the side that had 4. So I don't know much about Washington state politics, but it sounds like they may have a little bit of work to do up there. Like I said before, simply learning to count to 5 might be a good start. So that's the story with Macklemore in Washington State. If anything happens further on this, I'll update you. Otherwise, questions or comments, put them below. Talk to you later. Bye-bye.